Yeah.
Statement of statement. Number one, the statement.
Appeals are allowed. The land acquisition officer is directed to refer the representation dated so and so to the jurisdictional civil court under section 18 of the Act.
By two, fraud.
APL bonded.
Yes, enter करना. इसकी fraud पर.
Huh? Memo of retirement.
My lord, I appear for the appellant wherein I have filed memo of retirement.
The memo is accepted. Now she is permitted to retire. Memo is accepted. Office is directed to delete her name. Now what else? Substitution. IA. Substitute the name of the appellant. Want to substitute the government of Karnataka as appellant. It's about IA 4 of 40. Reasons assigned. Both right duly allowed. But this thing allowed amended cost title will be filed within 1 week.
But three, yes, okay.
Huh? That's correct. What about rectification of office objection? Huh? Weeks time. 2 weeks time is granted to comply with office objection.
Number four, demonstrator,
So learned counsel see it has been served or not. Appellant. Served, not despite has filed a memo seeking leave to retire. That's what the appellant appeal is dismissed. Appears appellant is not dismissed for want of cause.
five,
Of retirement. Retirement. And so they directed to delete the name. Memo is accepted. Appeal has been admitted. Let the appeal, record is there. Let the appeal be listed for final.
number six, recall.
Recall. ये number so and so reasons assigned. 2A3871 restore to file IA is allowed, and this appeal has been placed in order. Dated so and so passed by 25th April. 19 passed by the learned single judge. This learned counsel for the appellant fairly submits that this appeal is fairly covered by a judgment dated 9th of November 2022 passed in WA 51/2021. That's all right. So you say it's para to same order, right? And so instead of Article 14, 141 here will be that's the change. Disposed of. Yes.
Number seven,
Daughter of the appellant. Ah, learned. Hmm. This petition has been filed seeking a writ of habeas corpus for production of so and so, production of daughter of the petitioner, namely Kumari Neha. Learned additional government advocate, while inviting the attention of this court to statement of objection filed on behalf of respondent, submits that during the pendency of this writ petition, daughter of the petitioner has been traced, and yesterday and the custody of the daughter has already been handed over to the petitioner on 14/5/2022. Line below, the aforesaid submission is placed on record. In view of aforesaid submission, survives for adjudication. Body petition. What is SCGP? Nothing survives for the writ petition. Accordingly, same is dismissed. Dismissed as infructuous. After recalling also, again, this year you will comply, then 24 you will argue on admission, right? Weeks. Time is granted by way of indulgence, failing which appeal shall stand dismissed without reference to bench. It will not be entertained without cost, Mr. Now, this time, 25,000. Each time. Until to comply. Weeks preempted. Weeks time. Granted to comply with all. 11.1 and 11. Write the numbers. Be dealing from MFA 1018 bar 2020 and be listed separately.
Another matter, not related matter has not been connected. Different matters. That's why I'm punishing.
Learned counsel for the applicant submits that this appeal be heard analogously with WP number, MFA number, whatever. This for analogous hearing in view of a posted submission, this for analogous hearing along with FFA number.
12 of the
2 weeks time.
30. Yes, Nalwar.
Why court hall moved? Why have you moved this matter? Huh? Respondent has moved. Compromise. Why? Paid.
This is carried. And that this is there.
Paid.
No, here they are moving.
Settled. Respondent says it has been settled, Mr. We don't know. Let it be
Pass
passed
over.
over. Please wait.
Uh, 14.
Uh.
112.
1/12/2022. So it has, what is 1/12/20? You will have to file an application, madam, if you want, whatever. What is 1/12, Mr.?
Which time was granted?
In the light of order dated 1/12/2022, the appeal and submitted correspondent number. Since the appeal against respondent number 3 has abated, therefore same is dismissed. File an application. You should have by now, yes. Huh? Okay.
Your lordship, I appear for the respond number 1 in this matter, your lordship.
I appear for the appellants, my lords. My lords, we've taken summons steps to issue summons to the other respondents, my lords, but it's not yet been served.
Your lordship, may I make one submission? As a respond number 2 and 3 are the government, your lordship. It is the higher education department of the state of Karnataka. 2 and 3, your lordship.
Yes, Mr. Lakshmi Narayan. You are. Why have you gone? You are appellant.
Next matter.
Acha, next, right? In anticipation, right? Over. So 2 and 3, right? Accepts notice on behalf of 2 and 3, Mr. So and so, right? Let the appeal be listed for orders on admission
Much of-
next week.
Much of
Weeks time granted to comply with. 2 weeks time is granted to comply with office obligation.
Number 18.
Praise fund 2 weeks time to enable him take steps. 2 weeks. 2 weeks. 21 2 weeks. Next. Or 22 weeks. 2 weeks. Password. Interim order. 2019 you are not filing. Why? Huh? What happened?
Okay. Yeah.
Learned counsel for respondent praise fund has granted a week's further time to enable him to file an additional evidence.
Number 22. Yeah, this Sadashivappa.
Password.
Number 23. Yeah, Srinivas Gowda.
My lord, I appear for the appellant, my lord. Earlier occasion, IA was allowed, my lord, for early hearing. Some date may be given, my lord. Yeah,
Which order, Mr. Trust?
14/11/2022.
Order dated 14/11/2022, comma, what? IA 1 of 23 is allowed, let the appeal be listed for final hearing on 13th February 23.
Much obliged, my lord.
24. Srinivas Assembly.
Why? 829.
828 from the date of MC. We will be issued on the date. 1 minute. From there, the whole will be in date.
Learned counsel for the appellant submits. Learned counsel for the appellant submits that after the judgment dated 11th of September 2017 passed in MC number 1558/2017, comma, he had filed a review petition which was dismissed on
3/1/18.
3/1/2.
18.
Huh?
And 2/18, 3/1/18.
On 2/2/18, 2nd February
18.
2018, full stop. And thereafter this appeal has been filed.
Which is not.
Review petition was withdrawn on 2nd February 2018.
43/7/19.
Review petition was filed on, thereafter a review petition was filed on 2/2/2018, which has been withdrawn on 23/7/2019. It is further submitted that period spent in prosecuting the review petition deserves to be excluded. taking into, Swapnal has appeared on behalf of the respondent despite service of notice. Like below, for the reasons assigned in the duly supported. And in the facts, we find sufficient cause and delay control. I allowed admitted for hearing.
But 25.
Modification. Uh, What modification?
From the 19th, now the 19th last one hour. My lord, look at the rule of the KTB. That's what it Then once again, the extent of 28th February. Now, I was 3 days after they extended the fund. Now, I was giving the communication what was that fund. I only requested they could maintain the status, file their objections. They made the status. On the previous 2 months, they were allowing to do the work. Of course, I had submit on minutes at a later. My limited purpose, even we have. 14th of January, they have asked me, I have called my executive to remove and then place the new census. So if they could maintain a status quo, they consider it number 20 and 50 of our so it won't really prejudice their rights. I don't have a copy of the application. And even with I got paid after giving the application for a point, I was told what is the I have a copy of it. Even my very simple and even when passing the order that was passed in 2026, the respondent service, and the order specifically states that any process that I undertake is subject
So
to even
what happens, I mean, you are asking him to remove his belongings from the site and all that. Don't precipitate the matter till you file reply. We will grant you file.
tomorrow. Anything to stand the last. Tomorrow is so much better.
All right. Then it counsel for the appellant place for a shorter completion to enable him to file objections to IA 1 of 23 list on 13 January 23. I've given him one day's additional time.
13th is not. 13th is not.
Oh, not there. All right. 12th January list tomorrow. After he hasn't been seen. But it's really the reaction is disproportionate, right? I mean, as a council, I may have so many cases. Yes.
Number 28. Kumar.
Council, we should be doing this kind of.
Yes. No, I mean,
People are being decided. I guess.
One of the reason assigned duly support. Delay of 145 days.
Votes appeal against institution of
IA is allowed. It will be listed for order on admission in the next week.
But 27. People get,
Appeal is admitted for hearing.
but 28. Over here. Right, Swami?
Settle. Oh. Yes. This appeal has been filed. Judgment so and so, right? During the full stop, this court by an order dated so and so had referred the matter for mediation. Learned counsel for the parties jointly submit that the disputes between them have been amicably settled. In this connection, attention of this court has been invited to the report submitted by the mediation center. The terms and conditions for the that between the parties read as under, right? So this 3, 4. In lieu of aforesaid agreement. Right, that
I felt they have not filed one more.
Mediation center, last time only we have informed them.
Oh, yes.
They asked them to send one more. They have not.
They should send 2 copies, right? What is this?
In spite of telling them why do this.
We don't want to put it, you call. Arrived at between the parties, the judgment and decree passed by the family court is set aside and the marriage performed between the parties on 25/4/2004 is resolved by a decree of divorce. The appeal is disposed of in terms of compromise arrived at between.
Number 29. Case and B.
Admitted for hearing record.
30. Madhusudan amendment.
Same. Learned counsel for the applicant submits that the dispute has been amicably resolved between the parties. This for adjournment to him to report settlement is on 20th January.
31. B.S. Nagaraj.
What has happened?
Yellow.
Settled. Solution, no, but the marriage, that
No, no.
mediation report,
Mediation super failed me. Not reached agreement.
not settled,
Not set.
admitted for hearing record.
Number 32. Chandrasekhar Reddy. C.N. Ramlinga Reddy.
Admitted for hearing record. Settled. Settled. Matter has been settled. Admitted for hearing.
Number 33. Chandrasekhar Reddy. B. Mahesh.
For hearing record.
Srimati Srividya.
Admitted for hearing.
34. Chandramohan J.D.
Admitted for hearing record.
35. Kempanna.
Huh?
Appearing for the appellant, my lords, 35, my lords.
So does not survive.
My lords, I seek for our adjournment, my lords.
Why?
My lords, I have misplaced the files, my lords. I have applied for the certified copy, my lords.
Conditionally, saying that the order will come into force after 1 year. Therefore, wife only has filed. Now 1 year is over.
Yes. Nothing
My lords,
survived.
My lords, 1 week adjournment, my lords. My senior will argue, my lords.
No, nothing. There is nothing to argue.
I don't
We are-
have the file also with me, my lords.
That's why you start drafting SLP. huh? Apply for certified copy, you start drafting SLP if so advised, right?
My
Nothing,
lords, I
sir.
apologize. Only
I mean-
1 week, my lord.
No, unfortunate that you don't have file. We are required to tell you that there nothing survives. Then explain to you, this is too much. It's not our case. And you are supposed to, we should tell you that you are here to assist us. Not
Please, my
like
lords.
this. No, not like this that we go through the file. It's your case. We read it
Yes, ma'am.
and we tell you before passing an order.
Please, my
Nothing,
lords.
no senior, no junior, nothing. In our code, an advocate is an advocate and he appears for arguing the case. We are passing an order. If you are agreed, go wherever you want to go. This 1 year. This appeal has been filed against judgment dated 26th August 2019, passed by the family court, by which the respondent stroke husband is directed to take permit the appellant to join the matrimonial home after 1 year and discharge the conjugal obligations. Full stop. The period of 1 year has already expired from the date of the judgment. Judgment which was passed in the year 2019. Line below, therefore, nothing survives for adjudication.
Yes, my lords.
Accordingly, same is this. Yes. 36. And written. Admitted for hearing record. How do you know? You don't know anything about the case. That's why you are seeking an adjournment. How do you know that there is an interim order? Huh? Yes, sir. You have done your job. We have done our job. We have to. Is there an interim order? Interim order. How he knows? Huh? He only tells so that we should not ask any question to him. Not fair. This is not what you come to the court for seeking adjournment and for continuation of interim order. You are a young person, right? Why you should not read the file? Admitted interim order shall continue.
7. The Mohan Kumar Ji,
Admitted for hearing record. Yes. Right. Is he serious or just want to seek an adjournment? Only counsel for parties jointly submit that there is a possibility of amicable settlement of dispute. Hearing of this appeal is deferred by 1 week in order to enable the parties to report settlement. You don't know. How do you know? In order if any shall continue.
Number 39. Election. Protection in good time. Right. Paul was working at the cashier, but the must be employment of the appellate institution. So there is a random note of officiating cashier float prepared by each brand. And he was issued note and removed, asking to officiate at officiating cashier for 1 day. But there has been not, he did not obey that. Not he writes not that in the memo itself that he is not willing to work as cashier for 1 day. Or in official find note the objections raised by him are 97.
Option. They don't even they-
In by 2019, it is not voted completely. That is there.
Which?
370.
Not very circular not applicable to the petition of the respondent of one hearing not is annexed in. There are two panel of cashier. The one is the cashier appointed Lord for a period of 4 months on rotation basis, not for which not the annexed Lord C, that is the circular Lord where a special panel of cashiers is fixed by the not the office, not the office is fine, that is called special panel. Special panel can cashier work on rotation basis not for a period of 4 months. Whereas the respondent node here is a cashier node is an officiating. For officiating cashier node, annexation E, page 85 node is wherein node, the officiating cashier panel node is prepared node only to meet exigencies for 1 day or half day. When he refuses to work as cashier, question of removing him from the panel will not arise. Not annexation or C.
No, the question is whether if a person is posted as a cashier, whether he has the option to say that I don't want to work.
No, that is not there. Annexation C will not refer to an option. Page number 70, Lord should be kindly see for a minute.
3/11/2007 the circular which provides right on that option.
That is only for those who are on the special panel. Special panel cashier they have to work for 4 months. So that panel is not prepared to meet the exigency. But it is a regular cashier panel. Lord, they have got an option to refuse. In that event, their names have to be removed. Lord, kindly see page number 85. 85 annexure E. Now this circular node is for those who are on the special panel. As per present practice, as per present practice, our officer
was 3/11/2007.
please, this node is
3/11.
3/11/2007. The 11/2000 panel.
Where is it?
Annexure C. Page 69. Page 69. Annexure 3. 3/11/2007.
69, there is what?
I could copy of
68. 68.
69.
Our copy is 68.
But in that, you also can see page number 69. Page number 69 about selection for the post of cashier, or they are a permanent cashier on rotation basis.
No, he held the substantive post of an assistant.
He was not assistant. He has to not act as a cashier on as per my lord annexure E lord the circular lord officiating cashier. Officiating cashier are different from the cashier on special panel. So when an official cashier or official cashier lord, officiating cashier lord is asked to work for a day or a half day, but he has no option to say no. Question of removing him from the panel will not arise. That is what is the contention of the appellate subject. That aspect has not been considered within this. 2007 circular has been applied, and the learners intelligence says we should have removed him from the list. And that is not the case. That is only for the cashier on the panel, special panel. In their absence, if they are not able to attend the duty, the cashier on the officiating panel is directed to work for a day. Lots of the see, in this case also, he was asked to officiate for only 1 day because the regular cashier was only, which he refused. And also see the annexure as far as page 85 circular, there will be no change in other instructions related to the above matter as issued while order circular dated dated November 2, 1985. This circular I have found page number 193 of the pending. 193 note in circular dated 2nd November 1985. Now, this circular is meant for the officiating cashiers only. Now, this circular is not wrong. This circular is only applicable to the respondent.
Which page? One.
Page number 193. Last document in my paper. The instructions issued by paragraph 9 of circular dated 23/6/1977 in the matter of officiating arrangement in the post of cashier, and while circular dated 12/3/1984 in the matter of payment of officiating allowance to the employees appointed as officiating cashiers have been reviewed. Chairman is now pleased to issue the following administrative instructions in exercise of the power vested in him under Regulation 4, Review Section 3G of Regulation 1960. Our officers may select confirmed assistants with good work record to work as officiating cashier in the leave or replacement vacancies in the mentioned post of cashier. The officers should prepare a panel of assistants for this purpose of appointment of officiating cashier when the regular cashier is absent. The zone of selection for the preparing the panel may be restricted to accounts department in the division of service. This circular law is retained law. Even today, law is in operation. Where we want this circular law, the respondent is asked to work as officiating cashier to meet the deadline in 1 day or a half. Therefore, my subject to article 2007 circular is not applicable to the respondent because he is only an officiating. 2007 law circular applies to the regular cashiers who are on the special panel. So the learned judgment of English law did not address this issue. The first consideration is needed.
Stand here. Why? You are not appearing for intervener. Huh? Yes.
In the heading itself, taking in view of the sensitive nature, still only the just one thing is that there will be a passion that will make appreciating factor and panel in the panel. Appreciating factor or rotational basis. And this is going to be a problem. This is only to give them quality money. That is the objective of putting category into. Our earlier instruction. Our earlier instructions in referring to panel completing factors will hold ground, gather, take clarification, and clarify. Panel completing factors will be confirmed, company employee, assistant and the petitioner at page number 89. He gives us I request you to kindly withdraw the said objection. This is what I necessary for removing capital to the other. My knowledge also submitted in the 1985 circular law. Has it, has it mentioned, my lord, this is only from the accountant cadre, they mentioned it from the accountant cadre. But from here, it's from the assistant cadre. And please, even 2 times rejection be in the officiating part. And finally, the signature is observed that the post of officiating cashier is different from post of cashier. And this to meet the exigencies, they have made a panel. And in the panel, he's given a statement of withdrawal in the year 1985. And therefore, giving him an order of punishment and imposing him punishment. Additional. Eight, 2009 circular law. Page number 83. The earlier arrangement body is not maintained. That was not page 83. Our earlier instruction in respect of panel of office cashier with board ground gathers for the sake of clarification. It is clarified that the panel of office cashiers will be confirmed class 3 employees, assistants, NPO, type A, telephone operators, HCAs, and recorders. In that order, not all of them are covered in 2009 circular. It's not that equal. So my submission to your lordship is not 1985 circular, which is meant for applicating cashier phone is not still more good law, and that is only applicable to him, and he cannot put the office of to remove his name from that. Order will be passed today, please. Yes, Mr. You can write down. Party. Yeah, it's an order of remand matter, madam. Nobody can inquire into charges against you, right? You have a right to do whatever right. Employer. Oh, you are for the employer. We thought that you are arguing that I will indulge in corruption, nobody can inquire, and this thing all should be quashed. It's an order of remand. What's wrong? Taken up the department inquiry initiated against me. You have not taken a decision, right? Fresh. You are trying to help him by litigating. It has to be taken by whom? Respondent number 2.
So you should have by now taken a decision and pass a fresh order instead of you are trying to help him by filing this appeal, keeping this in petty. What? What? Thereafter, it was an order of remand. By now, you should have passed a fresh order. Nobody prevented you. We don't see anything wrong with the order. Yes. This inter-court appeal has been filed against an order dated 3rd of February 2020 passed by learned single judge, by which writ petition preferred by respondent has been uh, disposed of. Paragraph points giving rights to filing of this appeal briefly stated that respondent was appointed as junior engineer within bracket electrical in the establishment of KPTCL, right? The voting herein after with the corporation. The respondent at the relevant time was posted as section officer MESCOM. MESCOM Avina Halli branch Nagar Taluk Shivamogga district. The respondent was also given the additional charge as an additional assistant engineer. Full stop. It is full stop. The one Mr. Firoz lodged a complaint on 21/11/2014 against the respondent. Against the respondent before the police inspector Lokayukta Shivamogga inter alia stating that for preparation of the estimation report, the respondent had demanded bribe from the complainant, and the full stop. It was further stated that complainant had paid a sum of ₹1,000 and the respondent had called him to pay the remaining amount. Full stop. On the basis of the aforesaid paragraph, on the basis of the aforesaid complaint, the first information report was registered against the respondent for offences under section 7,13(1)(d), read with section 13(2) of Prevention of Corruption Act. Thereafter, the director of the corporation has passed an order under section 12 within bracket 3 of the Prevention of Corruption Act, as well as under regulation 14-A of the Karnataka Electricity Board Employees Classification, Disciplinary Control and Appeal Regulations 1987. Paragraph. The red single judge. The respondent being aggrieved by an order dated 29 by the aforesaid order dated 29/7/2017, passed by the director of the corporation, challenged the same in a writ petition. The learned single judge inter alia held that the order dated 29/7/2017, passed by the director of the corporation, suffers from the vice of non-application of mind, and no reasons have been no reasons have been assigned. Full stop. The matter, the order dated 29/7/2017 has been quashed, and the proceeding have been restored to the file of the director of the corporation to examine the matter in terms of section 12 within bracket 4 of the act, and thereafter to arrive at the decision afresh within a period of 4 weeks. Paragraph. The appellants, instead of acting in furtherance of the aforesaid order and passing a fresh order within a period of 4 weeks, have filed this appeal. paragraph, learned counsel for the appellant submitted that the order that order has been passed after due application of mind and reasons have been assigned. Paragraph, we have considered the submission made by learned counsel for the, on the other end, learned counsel for respondent, right? That very paragraph supported the order passed by learned signature. Paragraph, we have considered the submissions made on the record from perusal of the order dated 29/7/2017. It is evident that no reasons have been assigned for arriving at the conclusions mentioned therein. The order dated 29/7/2017 reflects non-application of mind. The same has therefore rightly been quashed by the learned single judge. So we do not find any ground to differ with the view taken by the learned single judge. Paragraph. However, the liberty is reserved to the appellants to pass a fresh order within a further period of 4 weeks. With the aforesaid liberty, the appeal is disposed. Petition was made with setting. This is between two brothers. Is pending. Which would be given a crisis. We request for 2 weeks accommodation so that we'll report settlement. 3 weeks further time is granted to learned counsel for the parties to enable them to report. The lordships kindly, lots of short accommodation on the ground that the impugned order is being the same only because of the fact that section K4 is being brought in. The facts of the case have a lot of opposition and short accommodation. Then you are arguing the case. What would we do? I was only trying to show. I was only trying to show my lord that I have to produce an extra K4. The translation of that is required. Case warrant is granted a month's time to enable him to file translated version of the documents on which the appellant seeks to rely. This concession was there, my lord, but that's the ingenuity of Ms. Patil. We'll see list on 23rd January. Identical have been disposed of. Lord, sir, the award is not assailed here, my lord. What is not assailed? Oh, Mr. What is this? Where is first volume?
Volume is there.
Both first volume here only. Huh?
Yes,
And both second volume. And this from 23rd January. Please,
Serial number 43, I appear for appellate, my lords. May I request a week accommodation, my lords?
Why? You have just got up, right? From the sleep, right? Huh?
No, my lords. I did not.
And week's time accommodation. Why?
No, I did not got up from sleep right now. I do apologize if I resemble so.
It looks like that only.
No, my lord.
It gives me an impression that you are feeling.
No, my lords. I am
just spoken up.
No, my lords. I am apologize. I was not my lord.
No, read paragraph 3. This thing, all this accommodation will go away. Read for us paragraph 3 of the order.
Please, my lords.
This all the reasons have been given by learned single judge. There is nothing to seek accommodation.
No, but
read it, para 3.
Please, my lords. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter on the following grounds. A, it has been consistent view
We
of
have
the
read it.
Please,
So
my lord.
we have read it. It is for your benefit so that the sleep goes away. You become mentally alert.
Yes,
Only
my
for-
lord.
Because we have read it. Don't read it.
Please, my lords. But
But what we want to say that cogent reasons have been assigned by learned single judge for allowing the writ petition which are enumerated in para 3. So there's
yes, my
no
lords.
grant of accommodation, nothing happens by accommodation.
My lords, only the fact.
If we grant you accommodation, once again you will go to sleep.
No, my lords, because senior wanted to argue in this matter and certain citations where we relied before the learned single judge, we wanted to place it before your lordship, my lords. That is the only reason on senior instruction I'm asking, my lords.
For the appellant praise for adjournment list on 19th of January 23.
Much obliged, my lords.
No further adjournment.
Please, my lords, please, my lords. Much obliged.
I say that before that, new orders are required to be passed on IA 1/21 as the appeal is within limitation according to IA 1/21 will dispose of then place for accommodation. Yes. Appellant is an institution, engineering college. It's a granting aid. It's admitted to granting aid. However, my lord, the government is not made a party either before the Education Appellate Tribunal or before the learned single judge of this arbitration. My lord, on three charges, lordships. One is unauthorized absence, and secondly, my lord, he was a nodal officer for the World Bank project TechWit, and he did not discharge his duties as a nodal officer. And thirdly, my lord, misappropriation of funds, 30,000 rupees. Not retired district judge, inquiry officer was appointed. And he gave a finding that all the three charges are true. And he did not need any evidence, respondent, in spite of giving sufficient opportunity. Thereafter, lordships, after giving a notice, is dismissed from service. The respondent hearing filed an appeal before Education Appellate Tribunal. Not even Education Appellate Tribunal also, lordships, after considering the evidence on record and also the material evidence produced, on two grounds, lordships, learned single judge says that notice issued after inquiry, it is a post-decisional hearing notice. That is one of the reasons why, the learned single judge of the Honorable Court, said that it's only after inquiry, a notice is issued. Your lordship to get it at page page 109, lordship. What is submitted an application for voluntary retirement? Oh, that is retired now. Well, that 64 years. That could have been considered. But at the time, since there was charges, he did not even come to office. And from 23/7/2007, he has not attended his duty. The tribunal has not assigned any reasons, right? This is what it has been. The tribunal order is also available. Given a cogent reasons on all the points. Voluntary retirement, government is should have been made a party because it's admitted to granting aid. Lakshmi Narayan is not concerned. You are saying government is not concerned. Not made as a party, what about Mr. Vandri? Second show cause notice. Second show cause notice, what is issued is at page 109 may be seen. The trust, after detailed deliberations, decided to award the punishment of dismissal from service to Dhananjaya and directed that show cause notice to be served to the above delinquent officer immediately. Therefore, Dhananjay, Assistant Professor, Electric Engineering, Toronto, is hereby called upon him to furnish explanation within 7 days from the date of notice as to why the penalty referred to above should not be imposed on him. Failing which, action will be taken under Section 92-93 of Karnataka Education Act, read with relevant rules applicable to the case. Copy of the report of inquiry officer is enclosed. For which also reply is also given at page 112. In detail, reply is given. The learned judge may not observe that its post decisional hearing has been given as per this notice. Unauthorized absence without leave, without producing medical records for over 3 months. The tribunal could not have granted any relief so far as voluntary retirement is concerned, because it's outside Section 94.
Yes.
Lordships, the learned single judge of this Honorable Court, my lord, has quashed the Educational Appellate Tribunal order, domestic inquiry, as well as the final order. That would not reinstate into service is not granted. However, he attained superannuation on 28/2/2018. The respondent. And my lord, voluntary retirement, my lord, shall consider the application of petition for voluntary retirement has been given at paragraph 4, page 4. The 3 months time was granted, my lord, and of course, my lord, the state government should be, because 85%, more than 85%, my lord, They have a say. And the state government is not made a party.
What has been struck down? Do you know the grounds why?
Millard, on the three grounds, Millard, the learned single judge has struck down. Number one, Lordships, the notice
First
is
ground is pre-decisional hearing law contemplates the pre-decisional hearing. You have issued the second show cause notice with a premeditated mind telling him that we have already decided to dispense with your services show cause. This is number one.
that is one.
Secondly, order passed by the findings contained in the educational appellate tribunal are contrary to the material available on record. Thirdly, the order passed by the education appellate tribunal is it suffers from the vice of non-application of mind. The appeal has been decided in a perfunctory manner. These are the three grounds. Instead of remitting the matter, what would have been the ordinary course? Ordinary course would have been to relegate him to the second show cause notice, asking you to issue a second show cause notice. But in the meanwhile, since the respondent is aged about 64 years, he has already retired. He has submitted an application seeking voluntary retirement. Therefore, learned single judge has molded the relief. When there is a limit to be vindictive, it's not that you are an enemy of the employees and you will drag them up to Supreme Court. You will not let him die peacefully. It should be the approach of the management.
Shall I submit candidly, Lordship? Voluntary retirement was being submitted earlier, it was rejected, of course. Nevertheless, Lordship, in the event of voluntary retirement to be considered, not suitable direction may also be given to the government and extend the time, Lordships, that would be benefited, Lordship. Because 3 months time was granted. Now, my lord, in view of me filing the appeal for this on the.
Why do you file every case? Why do you file an
Lord, since almost
what,
23/7/2007.
what has he done? No mistake. The only thing is that he has not attended a summit, which he had earlier agreed that I will attend and withdrawn the sum of 20,000, 21,000 rupees. And that learned single judge, by referring to the evidence, says that he has not misappropriated that amount. No misconduct. Why? I mean, are you being in management means employee approach all the time? They should be harassed. He should die. His legal representative should be brought on record. Is this what management is, or what management is to run the institution efficiently, or for harassing the employees like this?
Even giving the voluntary retirement benefits would help the employee, Lordship. That's different. However, Lordship, since he was unauthorizedly absent and no material evidence was produced, either before the inquiry officer or before the education operative. That's the only reason why, Lordship, this appeal is prepared. Voluntary retirement, my lord, if it is to be taken, my lord, sufficient time may be granted and the direction to be given to them.
The direction has already been given you. It is open for you to decide his application.
Extending the time, I only request this.
If you are confining your prayer, we will do so.
I shall confine.
This intra-court appeal has been filed against an order dated 17th of April 2021 passed by learned single judge, by which writ petition preferred by the respondent has been allowed in part, and the order dated 4/1/2020 passed by the education appellate tribunal as well as the findings of the domestic inquiry dated 2/12/2020 have been quashed. The management has been directed to consider the application submitted by the respondent for seeking voluntary retirement and grant of all consequential benefits. Paragraph. Learned counsel for the appellant, after arguing the matter to some extent, submitted that he shall confine his grievance only to the extension of time for deciding the application for voluntary retirement. It is urged that the application submitted by the respondent for voluntary retirement was not decided as the respondent had as the appellant had filed this writ appeal. paragraph. We have considered the submission made by learned counsel for the applicant and have perused the record. The learned single judge inter alia has found that that the law contemplates a pre-decisional hearing, whereas post-decisional hearing was afforded to the respondent as even before the issue of second show cause notice, the quantum of penalty was already decided, which is evident from the second show cause notice. After referring extensively to the evidence of the witnesses recorded in the domestic inquiry, former learned single judge has held that the findings recorded by the education appellate tribunal are contrary and the inquiry officer are contrary to the material on record. It has further been held that the contrary that it has further been held that the it has further been held that that the order has been passed in a cryptic and cavalier manner by the education appellate tribunal. Paragraph, however, taking into account the fact that during the pendency of the proceeding, the respondent has already attained the age of superannuation and had submitted an application seeking voluntary retirement, the relief has been molded. The order passed by the learned single judge does not suffer, even otherwise does not suffer from any infirmity warranting interference of this court in this intra-court appeal. Paragraph, for the aforementioned reasons, we are inclined to grant the relief to the appellant and direct that the appellant shall be at liberty to decide the application submitted by the respondent seeking voluntary retirement within a period of 2 months from the date of receipt of copy of the order. To the aforesaid extent, the order passed by learned single judge is modified and the result appeal is disposed of.
The 3 months.
2 months.
3 months.
How does it?
Because government is also there, Lordships. From our side, within a week, we need to.
He will take care. Lakshmi Narayan.
Without there being any directions, Lordships. In the event, because 85% is government granting aid.
All right, 3 months. What a decree of no into the past by the admitted for the
Extend.
interim order granted on earlier occasions to continue. It is directed to secure the reform of the country. The DRIT directed me to deposit a sum of rupees 35 lakhs. The condition for the entertaining of the appeal. Challenging that waiver before this court on one ground that there is an excess. The property was already sold. But an excess in after realization of the entire loan of the bank. A sum of rupees 1 crore 11 lakhs was still in the custody of the bank. So therefore, this 35 lakhs need not be deposited. The property was already sold. The entire loan was discharged. So this petition came to be dismissed, telling that the amount has to be deposited. But I am now before this court, not even wanting to challenge the same. My purpose in restoring the writ petition is only to seek refund of this 1 crore 11 lakhs. Those are my instructions. Amount is kept in a suspense account with the bankers for almost several years. You don't want to return, right? No. First of all, is it correct that an excess his property has been sold, entire thing has been recovered. And an amount, just a minute, just a minute. Just a minute. It's not necessary that whatever is said from the side necessarily you have to oppose. Huh? No, no. Is it correct that an amount of 1.11 crores?
Page 27, my lord.
Is in excess? It is lying in suspend deposit. Why don't you refund the loan accounting? You can't. Maybe he does not want to challenge.
We only want refund.
You file a joint memo, Mr. The bank will agree. If you. No, this is too much, Mr. That even after recovery of the amount, you will keep him in litigation. Why? He's saying, I mean, did you get it that he will withdraw the challenge to the sale? He has said so. If he withdraws
First ground,
if he withdraws the challenge to the sale, what is the difficulty in refunding the amount?
We will keep it present before the court and I will file an affidavit.
I
will file an affidavit. 12 years they've had to manage. 12 years they've held my money. I'll file an affidavit of both the directors.
You file an affidavit, thereafter we will
No,
direct.
I will file it.
Why? No, I mean, the manager will not meet them, he will keep them waiting, like, what is their business? If he files it before us, and we will direct you to refund, why he needs to take care of the manager and to massage his ego? Why? Why back? Why back? No, the way you are opposing the prayer, we have reason to apprehend that he will be harassed. That's why we want. Counsel for the petitioner submits that he shall file an affidavit of directors, affidavit of both the directors of petitioner number 1 company, stating that they shall withdraw the challenge to the sale which has already been conducted by the respondent bank, and are interested in seeking refund of an excess amount of 1.11 crores, which is admittedly lying in deposit with the respondent bank. Let the affidavit be filed on or before.
I'll file it tomorrow. My request instead be on 16th.
18th January. 19th January. The moment we tell a date, the council will say that, because see, you have been brought up in that atmosphere that whatever comes from this court has to be opposed. So no, not sorry. Why you should be sorry? This is our experience. It's not happening in your case. It happens in every case. The moment we fix a date on our own, there will be an opposition. No, I am not there. I have personal inconvenience. So like lawyers are trained, their mindset is like that what we feel is Mr. Shyam Prasad, right? What we feel is that we are here to decide a case according to the legal position and with your assistance. This is our approach. But you perceive that these people are our enemies. They can never say in my favor. Like this is the approach. We are telling you because we see. No. Generally, we are telling. Generally, this is what happens. Even in a date, if we mention a date, It is never accepted. It's always said, no, no, I'm not there, going somewhere, not well, something like that. They will tell in advance that they are not well also. That on 16th I will not be well. Okay, thank you. Yes. 90.
Must appear for the petitioner. Petitioner education institution is accorded with the status of minority linguistic. Not presently involved in the form and part of the association of the fourth respondent. Not the fourth respondent has entered the constitutional agreement with the state government.
Mr. Ramesh does not survive.
Prayer survives me.
Does not
The
survive.
central prayer will not survive. Prayer will survive because it is second prayer, first prayer and second prayer.
Board counseling for admission to, they want an independent counseling. Hey, you, why don't you supply a copy to Mr. Ramesh? You need counsel for the petitioner. We can't say it does not survive. He is not entitled to that relief. That's a different thing than saying does not survive. He is claiming the relief. According to you, is not entitled. That we will decide. Let a copy of petition along with annexures be supplied to Mr. N.K. Ramesh, learned counsel for respond, who appears for respond number 3.
We must encourage.
3.
Who must be a Sachin? Who must be a Sachin?
N.K. Ramesh and Mr. B.S. Sachin, right?
And 4 members of
Mr. B.S. Just a minute. B.S. Sachin and Mr. N.K. Ramesh, learned counsel who appears for respond number 2 and 3. Let the petition be listed in the next week. Notice is directed to reflect their name. We are not issuing notice. We have not heard it. He has not argued anything. Mr. Ramesh was sitting, so advance copy. He should have otherwise supplied. Notice. Notice. Yes, Mr. Who appears. Special counsel. Should notice. Yes. Which matter? 13. What memo? Yes. Appellant is present in person. So and so respondent along with her counsel, respondent along with her counsel is present. No. Right, sorry. Appellant in person, respondent along with his counsel present, right? Learned counsel for the parties. This appeal has been filed against judgment dated 22nd November 2019, passed by the family court, by which the petition filed by the respondent under section 13 of the Hindu Marriage Act has been allowed, and the marriage between the parties has been dissolved by a decree of divorce. Paragraph. Appellant as well as learned counsel for respondent submit that the parties have arrived at an amicable settlement. Joint memo duly signed by the parties has also been filed. The joint memo, the terms and conditions of the memo read as under. 3 to 7, right? Full stop. Line below, in pursuance of the aforesaid compromise arrived at between the parties, the respondent has handed over a demand draft of ₹7 lakhs to the appellant. The appellant today, full stop, right? In view of compromise arrived at between the parties, the appeal is disposed of in terms of compromise arrived at between. So they get to this. Whatever it has been, it all will be formed part. Get their signatures.
Except for the husband. I tried filing petition for divorce. And that will be, nobody is appealing. And we have said on last date also, you said the same thing, 8/3/2022. Amicable present. You were there. You said it is likely to be amicably settled. We are ready. The issue may make. What vacating stay? Rejected. Nobody is appealing. Visiting right issue. Yes. It's only IA 1 of 20. Vacate. Nobody is appealing. Corresponding. They are non-proceed. So nobody is there. What happens? Dissolution of marriage, vacating stay means you will remarry, right? Advocate, the solicitor junior is appearing. I have spoken to Mr. What has happened is may make consultation. No, you want time for amicable. The senior counsel for the appellant. Respondent. Praise warrant is granted 3 weeks further time to enable him to explore the possibility of amicable settlement of this.
Yes, sir. Bangalore Mediation Center. He has kept the second report assigned first file. First set. ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ ಯಾರು ಬಂದಿದ್ದು ಹೇಳಿ ಹುಷಾರ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್.
You understand what you say, right? Huh? After 3 weeks, we have said after 3 weeks. You can always move or mention memo, right?
Let's appear for the petitioner in 49.
Oh, Mr. Naik.
Let's appear for the petitioner in serial number
No,
49.
that interim order has been stayed now by Supreme Court.
No, that's what I was told. An ex parte order has been made. Lordship may have it after 4 weeks. We'll move the Supreme Court and come back.
Learned senior counsel for respondent submits that against an order dated which date? 22nd of November 22/11/2022. The respondents had filed SLP number. You don't have the order?
I have a copy of it, my lords. It reads issue notice in the meanwhile.
Yes, sir.
There shall be a stay.
Had filed SLP number 22712/2022, in which an interim order has been granted on 14/12/2022. Paragraph in view of proposed submission, learned senior counsel for the petitioner, place form is granted 4 weeks time. List thereof.
My lords, in this matter, serial number 50, on the last occasion, there was a discussion with regard to furnishing of inquiry documents. My lord, unfortunately, neither the advocate on record nor myself have a copy of that. Then I find he has filed all these documents in the original suit against which an RFA is filed. That RFA is before your lordship. It is also mentioned they have to make an application to club these cases if they want to. That has not been filed yet. So the documents are available in RFA. The RFA can be put up along with this writ appeal. Your lordship may refer to it. I am not able to secure a copy of it and furnish it to my learned friend. We are relying on whatever papers he has filed in the appeal.
Your lordship may take up both the matters together.
Which matter?
The RFA also. It is because you on your lordship's board, the RFA also, your lordship is, this is the.
Yeah, he has to make an application. That's what the cause list says of his note. Because some other counsel is appearing in the RFA, senior counsel, Mr. Vishwanath, I believe.
Hello, you will board.
Chief Justice.
I think according to the roster, this bench hears it. Hello?
RFA is also
No,
here.
you are not properly assisted. I mean, we do not have the jurisdiction of RFA.
I think, my lord, according to the roster, I think your lordship is has got.
Oh, Mr. Rao, that's why we are telling you, you are not properly assisted. You don't deal with RFA. You don't have any idea. Neither people assisting.
My lord,
you
I will make an application, my lord.
Which labor court, what will industrial tribunal is hearing, what they can tell you, but not about RFA, we believe.
My lord, I will make an application, my lord.
4821 for this very purpose time was granted.
My lord, your lordship may pardon me. Your lordship may pardon me. On the Monday, my lord.
Refresh your memory. Learned senior.
Your lordship may kindly see. I have nothing to do. Lordship may have it on Monday. By the time, my lord, we will make the application.
Granted a week's time to enable him to comply. No. Enable him to move an appropriate application seeking analogous hearing of this appeal along with the regular RFA, regular first step.
Right.
Week's time. Yes. Second January 23, you prayed for adjournment, it was adjourned. Then huh? Yeah. Huh? Check the outcome of this. If he gives consent, I was promised. We are ready to give. He gives the matter is pending before the owner of the matter is pending before me. What proceedings are you are appearing? No, not declaratory. Mediation center. What? Why then? Why are you seeking at them? You will get more in the review of items. On 13th for what? Passing judgment and decree. What is this appeal about? Divorce petition dismissed, so what happens if we agree, whatever? So this has to be decided, right? Yes.
Divorce petition was filed by the maid. I think allowed.
What she-
Yeah, filed it with her family. It is to be confirmed. It is that that thing is confirmed. That you get a proper. Before settlement, that's the when they request.
Ask him.
No, you want to report a settlement in the pending proceedings. Thereafterwards, come back and
If it is fine.
this will, he wants to withdraw it. If a compromise petition is filed there, then it will, this you want to withdraw it. This will be withdrawn. This will be withdrawn. It will survive, you want to withdraw it. This is withdrawn, you are ready for settlement. We'll record it. You give a statement here. We'll record. 13th, nothing will happen unless you make a statement here. You make a statement that you will withdraw this in case that is settled there. Nothing will happen on 13th. He is making a statement unless you you don't want to make a statement that you will withdraw this in case there is a settlement there.
That's what he's making a statement right now. You have heard him. Perhaps there's no question. He said so, right? I told her last time I mean, not yet. So I told him inside also, do that effort state. Instead of waiting for also 30, do that. Who came? He is not saying today, he is ready. But you are saying you are ready, right? We don't know. We cannot force them to what he has said. You have heard him. What did he say? They want to wait for only then we come. Then you are not ready to make that statement. Then what should we do? You tell us. Supposing if you would have been a judge, what you would have done, tell us. So you would have a judge saying, being a judge, I will take it up on Monday. We asked you, supposing you would have been a judge, what you would have done. So you have told us that you would have said that I will take it up on Monday. So, Monday. Hey, Mr. I don't want to take any because some 4 days. Yes, 4 vacations and no, it will be completed today also. Don't worry, Mr. 4 witnesses. That doesn't mean that what you are trying to frighten us by saying 4 witnesses. Oh, and it's not beyond your capacity. Beyond your capacity to decide until unless I give synopsis. Is what you are trying to tell us. It's like any other appeal which we have been deciding. Don't tell us. be fair. I mean, that I appreciate that if first sentence, if you would have told that, sir, I have traveled today to reached today to Bangalore, I could not prepare, please grant me time. That we appreciate. But you are saying all sorts of story. He is telling us, is that story compromise, Monday, this thing. Say so, right? That you are not ready. Senate counsel for the appellant prays for adjournment to prepare the case and argue the same. It is made clear that no further adjournment shall be granted. It is wrong. 18th of January 23. That's 52.
Already affect the treatment of the legal judgment. So that
Right. Oh. Oh. But say very just no, let us be clear on facts. The same judgment has been upheld. Yeah. What will we do, Mr.? I mean, you have seen like everybody is traveling from. So what will we do? It's only 12:30 today. I agree with 60.1. You tell us the facts. No. What about tomorrow? Friday, you understand. Day after tomorrow is what? Oh, Friday. Friday we have split benches and all that. But why, Mr. 2014? No, you have to, if which judgment is covered. Oh, then you tell us, Mr. What is there? Hey, you have argued, Mr. Suman. We always thought that you are a fair counsel. You would say that my lord may record my submissions, but this is you have argued, Mr. Same judgment has been upheld. Primarily, Mr. PCC case is a judgment in rem, delay and laches explained satisfactory. Third party interest created extraordinary jurisdiction under Article 226. These are all the points. Assuming that res judicata does not apply, you did not file any previous. Hey, Mr. Suman. Para 13. A50. No, not pivotal. Res judicata, you said it does not apply, you did not file any petition. Come to read 2, 3, 4, 5. The counsel, it's not. Same judge. By referring to the fact I read the judgment. No. So we are putting a question to you as a counsel. Like you have to, you are an officer of the court or not. Prices of immovable property have skyrocketed. You will do your best. Take this matter to Supreme Court, that apart. But as an officer of the court, you must be able to say fairly that yes, sir, I have argued the case, this very judgment has been upheld. These are the issues which are against me. That you should be able to, what I mean, you are not a, like, this much of fairness we expect. You can say that this is the distinguishing feature. I will, the res judicata, we know that you are not bound by res judicata because you have not filed. What about 2, 3, 4, and 5? Just wait. Hey, just a minute. What about 2, 3, 4, and 5? Then so the court says that the very same judgment, extraordinary distinction under Article 226, you are not entitled. And you expect us to say that yes, you are entitled to extraordinary discretionary relief under Article. What would be an ideal situation? You understand, right? But I mean, this is what it is. All right, the res judicata is fine. What happens to this other judge? That's it, Mr. Suman. We will say, thank you. Why should you seek an adjournment? That's all. Following this. Yes. We will record. Yes. Yes. No, it's a well considered judgment, 93 pages. No. Right. It 40 pages. I mean, considering the standard by it's we can say he has written this 40 pages means very elaborately dealt with, right? That's it. Thank you, Mr. We will record your submission. Fine. Yes. All right. Yes. Mark it. This intra-court appeal has been filed. This intra-court appeal has this intra-court appeal has been filed against an order dated 25th February 2014, passed by Lawrence Single Judge. Passed by Lawrence Single Judge in WP number 16858/2004 and WP number 9942-9949/2014, by which the writ petition filed by which respondents, Mr. Suman, respondents number with respondents in this appeal. By which writ petition preferred by Mr. Appeal. Just a minute. We'll get it. Writ petition preferred by respondents number. Oh, no, appeals have been dismissed. Here, the writ petition filed by the appellants. Appellants seeking quashment of preliminary notification dated 23/8/1998 and 1/9/1998 issued under section 4(1) and section 6(1) of the Land Acquisition Act have been dismissed. Paragraph. It is not in paragraph. It is not in dispute that along with it is not in dispute that that by a common judgment, by a common order dated 25th of February 2014, writ petitions number 16858/2004, WP number 9942/9942-9949 of 2014, and the comma, WP number 224445 of 2004 and WP number 18 and WP number 2004 were decided. Full stop. Paragraph. Learned senior counsel for the appellant fairly submitted that the order that the aforesaid common order passed in WP number which 2245. Acha, all right. WP aforesaid common order passed in WP number 16858 of 2008.
8 by 8, it is 8 by 8. 8 by 8.
16858 of 2004 was challenged in WA number 978 part 2014. It is fairly pointed out that the aforesaid writ appeal has been dismissed by a division bench of this court-wide judgment dated 15th of December 2022, passed in WA number 978 of 2014. It is also contended that the appellant in writ appeal number 978/2014 has filed a special leave petition before the Supreme Court. It is also contended that it is also urged that the writ petition preferred by the appellants cannot be held to be barred by res judicata as has been held by a division bench of this court in WA number 978/2014, as the appellants had not previously filed a writ petition. Right? Paragraph. On the other hand, learned senior counsel for respondents, senior counsel as well as counsel for respondents have submitted that the issues involved in this appeal are squarely covered by a judgment dated 15th of December 2022, passed in WA number 978/2014. Paragraph. We have considered the submission made by learned counsel for the parties. Full stop. And have perused the judgment dated 15th of December 2022, passed by a division bench of this court in WA number 978/2014. Full stop. The division bench has framed the following issues for consideration. Para 13, right? 1 to these 5. Court para 13 has framed the points which arise for consideration as follows. Court para 13, right? Paragraph. Thereafter, the division bench has dealt with the contentions raised by the parties, and by assigning reasons have arrived at the conclusions holding that no interference is called for with the order passed by the learned single judge. Paragraph. We are in respectful agreement with the view expressed by a division bench of this court. Delete on principles of paragraph. Paragraph taking into account the fact. No, we are in respectful agreement with the view expressed by division bench of this court-wide judgment dated 15th of December 2022, passed in WA number 978/2014. As the aforesaid judgment squarely applies to the fact situation of the case insofar as it pertains to point number 2, 3, 4, and 5 are concerned. Full stop. Even otherwise, the common order dated 25th of February 2014, passed by the learned single judge, has already been upheld in the aforesaid writ appeal. Therefore, on account of principles of parity also, we agree with the conclusions recorded in the order in the judgment dated 15th of December 2022, passed in WA number 978/2014, paragraph, for the aforementioned reasons. The appeal fails and is hereby dismissed. Thank you, Mr. Suman. Yes. He is appearing, right? Okay. So then, madam, every case you have to write separately this order. There are two appeals. There are two appeals. Two. Okay. Okay. So don't, these, whatever you say, 53 you say, order sheet, Mr. So and so has permitted, has filed a memo seeking leave of the court to retire from the case, he is permitted to do so. Then say record closed and then same order, right? Whatever has been typed. Other case, mark Mr. Suman's presence. Thank you. And then pending interlocutory applications are disposed of.
Different view. Entirety is concerned.
We should have.
I should have.
Trying to seek an injury. Ah, where is Mr. Shivramu? He is coming. Let him come. Is it? Why are you looking the way? Ah, yes.
Password 58, the L. Srinivas Babu, T. Subramania. Password 59, S. Shivaram.
Yes. Ah. Reality. So what wife's petition allowed? Allowed. Or for the husband? Wife.
On the part of people and saying that and he has not deeper into what exactly he for our maintenance and
Even that dictation of writ appeal in white sheet. White sheet first. Huh? Writ appeal. White sheet. Yes. The allegation of reality doesn't, can't see from the judgment.
Because he's only interested in animal. What is, human?
Nothing.
It's how long you are staying separately? 2004, almost 18 years. More than 18 years. Any issues from the marriage? You would be satisfied if some permanent alimony is granted.
Not doing anything, right? Do we?
First time somebody is saying
Yes.
that I am earning.
Otherwise. Yeah. So What is he doing?
Taylor. You are remarried, he says. You are remarried, he says. No, no. If you are ready to take her back, then why did you file this petition? Then if you say that he is ready to take back, then we may have to quash this. We have to set aside this. Hello, dear.
Let him file an appeal. Just trying to away from payment. This is another like this thing, right? Taking a stand like this so that you are not required to pay permanent liability. You also know that she won't come. You also you can't stay with her. So then what I mean, what do you do?
Taylor.
What is your income? $50,000, you know, by all standards. And no, you don't dance. What is as an officer of the court, you tell us what should be the reasonable this thing. You know, you have gone through evidence, you know the status of the parties. He may have said that only 5,000 I will pay, but whatever we are asking you as an officer of the court, what should be the amount? What should be the amount? Tell us. We are not recording your submission, mister. We are just asking what should be the amount. As an officer of the court, we are asking you.
What is the RTC? There is one RTC produced, exhibit P2. What is that? Huh? That Where are you doing this tailoring work? Tailoring work, where are you doing?
What should be the quantum measure? You tell us. We are not that we are recording your statement. We are just asking this. What should be the quantum?
We can expect that. Oh, yes.
He's saying 50,000. Yes, said inordinately. So even if we double it, don't see 1 lakh. That's why he's saying. So then all the more necessary for you to maintain cordial relations with her. Huh? No, that's, therefore, it is advisable to amicably resolve the dispute, right? 5,000, 50,000 is very low amount. Isn't that, I mean, you have to be reasonable. Nobody would settle 50,000.
Not have 2 years
No, on what ground you have gone to the trial? On what ground you have sought the divorce? It is not your case in the petition that she has been alleging that you have an illegal affair. It is not your case. That is only a defense taken by her. Therefore, the trial court has held that such a defense amounts to cruelty. On that ground, it cannot be granted because that was not the ground on which you have gone to the court. Therefore, it has to be set aside on that ground. It's simply said. This has to be allowed only on that ground because it is granted. Divorce has been granted only on that ground that you have been making allegations. That petition is filed on what? You are not even gone on that ground. You have only filed under cruelty. You have not gone to the court in that. You can always go, but you have not gone to the court invoking 1B. Then there has to be issue without even urging any point. How can you? You are not ready for settlement. We'll decide it on merit. Not ready.
Yes. Madam,
We'll allow it. Only on that ground, 2 grounds it has been allowed. Both are not available. That is not pleaded so far as that allegation of having a illicit relationship. That was not your ground in the petition. Yes. This claim is first appeal filed under section 28. Tailing the judgment and decree dated 30th March 2015. As per this point report in MC number so and so, wherein the marriage of the appellant with the respondent that was solemnized on 1/4/2002 was dissolved by a decree of divorce on the ground of cruelty. The heard the learned counsel secretary for both the parties and on the verification level. The facts is as revealed from the reports which would declare for the purpose of disposal of the second art. Marriage of the respondent was solemnized before 2000. Mangala Kalyana Mandapam as per the rights and customs. The couple resided together about 2 years after that. The relationship between the couple was straight. Failure of the difference of opinion between them and the respondent had their push and the appellant had therefore allegedly left the company of the respondent, took shelter the parents' house. In the circumstance, Section 31(1). Respondent so and so in the on the ground of guilt. And he had sought for a to dissolve their marriage. Dissolve his marriage. But had interdicted in the proceedings and that filed statement for denying the fiction elements. He had also contended the respondent was having an illicit relationship with one Srimati Harinakshi, and therefore he did not want to continue continue the life. Before the trial court, the respondent had examined himself as PW1 and got documents as exhibit P1 and P4 in support of his case, whereas the appellant had examined herself as RW1 and got marked 1 in support of the trial court. Then 23. Told the marriage between the parties that was solemnized on 1/4/2002. And the counterclaim made by the respondent seeking maintenance was being agreed by the judgment and the number 2000. Wise before this court from counsel for the friends submits that the trial court has allowing the petition as the respondent has failed to the ground of cruelty. He submits that the trial court has allowed the petition mainly on the ground that has allowed the petition on the ground, mainly on the ground that the allegation made by the respondent appellant against the respondent that he had an illicit relation with Srimati Harinakshi with amount of cruelty, and also on the ground that the appellant was guilty of deserting the respondent without there being any sufficient cause. He submits that both those who are not arguing the petition filed before the trial court by the respondent, and therefore the trial court has held in allowing the petition. The contrary counsel appearing for the respondent has argued in support of the judgment and submits that appellant voluntarily has left the company of the respondent without there being any sufficient cause, and the court was justified of the petition and therefore accordingly placed to dismiss. From a reading of the petition, from perusal of the petition filed by the respondent before the trial court, seeking a decree of favors, it is seen that the purpose approached the trial court, we invoking section 13(1)(1)(a) of the Act for the purpose of getting a decree of favors under section 13(1)(1)(a) of the Act. The party who approaches the court is required to prove that after solemnization of his marriage, his or her marriage with the respondent, he was treated with cruelty. And as a result, it is impossible to, it's not possible for the party approaching the court until the marital life with the others, with the respondent. The reading of the government's made in the petition, it is seen that the respondent has not made any specific allegations against the appellant with regard to the incident was caused by her. Also, there is no allegation in the said petition. There is no averment in the said petition that the appellant had accused him of having illicit relationship with one Srimati Harina. It is only in the statement of objection filed by her for the first time, yes, made a statement that the opponent having illicit relationship with Harina. The respondent has not approached the court seeking was against the appellant on the ground that she was making an allegation against him that he had an illicit relationship. Harinakshi, illicit relationship with Srimati Harinakshi. And therefore, the court was not just holding that the allegation made by the appellant acts against the respondent in the statement of objection would amount 20 for the purpose of granting a decree of the further it is of the respondent has not the court seeking a decree of divorce on the ground of assertion. The respondent has approached the trial court only under section 13(1)(a) of the Act. And not under section in the absence of any pleading issue. Assertion. The trial court was not justified holding. Appellant was also guilty of deserting respondent without there being a sufficient cause, and then thereby granting a decree of divorce in favor of the respondent under the circumstances hereof be considered the judgment and decree passed by the trial court allowing the petition filed by the respondent dissolution of marriage between the parties. Not sustained according to the following order. It is known as first appeal is allowed. The order date, so and so is status. This matter was heard on the last occasion. It is only for to hear you with regard to the alimony. So offered them already.
Number 65, government educate, Vivek Fuller.
Not even present.
Why 12(1)(a) was invoked? 12(1)(a).
So on the ground. Because stated means that we were graduate. And then given the date of birth is furnished. One day.
What is 12(1)(1)(a)? 12(1)(1)(a), what is 12(1)(1)(a)? 12(1)(a) is marriage not consummated owing to the impotence of the respondent. Petition is filed under 12(1)(a). 12(1)(1)(a), what is the allegation about impotence? No, nothing. Next ground is only desertion. Only cruelty. Therefore, under 12(1)(1)(a), you are not pressing it.
What is the allegation pertaining to cruelty? Having
Oh. Amount. Design. So one is that delegation which he has to make. But she says that if you are giving rudely and whenever he extended, she has to prepare that I will come to. Contesting before the trial court, she has remained as part before this court also. She is not.
Yes.
There are also about dependency of the fiction particular by from the 1 still pending. Filed by her. Particular was filed by her, filed by the upper entity. It is not the work. Define the field change. They are very intelligent. Therefore, when we go to make complaint about treating political partners in life or election, the court will not try to handle it. Therefore, fact, stigmatization politically is not resolved. The politically analysis will largely depend upon the type of life the parties are expected to of the economic. It may also depend on the we not import from we may not go and travel with it. There may be a generation gap between my assumption about the children who manage to take care of. You need to get not have the and that is also the upper end of the month of 2018. No, the other is trying to push for another. Because of the municipal act, it's still pending consideration. You don't know, the finding given by the government are coming for the individual and that. Now, we learn from the mental state, and suffering and so much. For some, it is not. How is it of the immediate treatment, calculated person, sustain very, very sustain reprehensible,
All right, you have read it. Yes, thank you. Yes.
You have not read the judgment then.
That's
We have
why
said,
at least your colleague should read. What is this? No, I mean, really surprising, right? He did not take the pain of reading, going through the judgment and just No, Mr. Ravi Shankar, is you are a senior counsel, you must share our yesterday's experience. Despite being told to an arguing counsel that we want the citation to be paginated, two counsels assisting him did not paginate even during lunch break. This is what it is. And the client was present in the court. In his presence, they have the order. Your colleague doesn't take the trouble of going through the judgment. What, Mr. You come here only for that Mr. Ravi Shankar is busy before court all. Huh? Thereafter you could have come, right? You have been sitting here and talking to him. Instead of it, you could have asked the court officer that please give me a judgment. What has been pronounced today? He would have handled it. Good.
Court officer.
ಪೆನ್ಸಿಲ್ ಇಲ್ಲ ಕಣ ಮುಗ್ದೋಗೈತೆ ನಂಬರ್ ಬರ್ಸ್ಕೊಳಲ್ಲ ಎಲ್ಲ ನೋಡಿ ದುಡ್ಡು ಕೂಡ ನಿಮ್ ಚೇಂಬರ್ ಇದ್ರೆ ಎರಡು ನಿಜ ತಗೊಂಡು
Court officer. Court officer, sir. Sir, serial number 37. Sir, ಕೇಳಿಸ್ತಿಲ್ಲ.
37 admit ಆಯ್ತು. Submit call for record.
Okay, sir. Thank you, sir.
Wait. Round, mister. We have waited for all of you. Serious? Settle, right? This 52 WA. So what? Ah. Settle. When do you want? When do you want? Let's tell us. 19th. Learned 52. Learned Council for the parties jointly submit that the dispute between the parties has amicably been resolved. However, they pray for short accommodation to no. However, Learned Council for respondent prays for a short accommodation to enable him to indicate the manner of payment of the amount due to the appellant. In view of aforesaid submission, hearing is deferred list on 19th January 23. Let the appeal be listed for reporting settlement on 19th of January 23.
Who is paying money to whom?
He's paying. You means what? Respondent.
Respondent is the landlord. You are paying the tenant. We will pay for payment of amount, because that cannot be done.
All right.
We will say for
So,
reporting
all right. So you say has been settled. Dispute between the parties has been amicably settled. Then delete everything else. However, Learned Council for parties pray for short accommodation to enable them to report settlement. List on 19 January 23. 34.
and rest to the government. And rest to the government. We cannot stick by paying them. That's different, but it cannot be.
Yes. Where were you in the first round? Oh. This is 2014, Mr. Why? There's no question of apology. Only thing is we are asking you why we should adjourn. Which senior counsel? Which senior counsel? Where were you in the first round? Why? That's not a ground. That even CPC says that counsel busy in another court is not a ground for adjournment. So, overruled. Now, what is the appeal about? What is it? The order of appropriate authority, handling the license of the appellant hospital for transplantation. Oh. Why do you want to deal with kidneys? Good, good, good. I mean, your license has been cancelled. You are the patient. No. Hospital. So, license has been cancelled. Good, no. Consent of the patient for transplantation of kidney. Patient for the single. Medical hospital managed by Global Brand Healthcare Services Super Specialty Kidney Transplant. Read paragraph 15. Mr. What makes you so confident that you can get away with whatever you want? And supposing if we decide what will happen, you will start drafting SLP now. Read para 15. There's nothing. You don't have this registration certificate for transplantation of pancreas, and you are doing transplantation of pancreas. Everything, right? Taking law in your own hands. What is this? Nothing. That's the finding. That's on what your ground it has been considered. And you are not in a hurry, right? After 8 years, you are still seeking an adjournment. That shows you are not in a hurry. Thing absolutely. Rightly saying. Make out a case. Nobody is preventing you. Make out. Yes. So you collect the file. We will give you the copy of the judgment. Then you take the file from senior counsel. He will also be relieved from an obligation to come to the court and to argue. Why he should trouble himself by coming to the court? So, we are dismissing, right? We will say that you have no instructions to argue, no representation therefore. You are saying no instructions to argue. And pancreas also they are taking out. Taking out pancreas of people and selling it for others. Good. You didn't go there for treatment. You never went to the appellant hospital. Good. Don't go. That means don't go. Your pancreas are safe. Otherwise, they will take out these people. Transplantation of pancreas also giving advantage. Name. We are asking your name only. So that later on you shouldn't say that I didn't appear on the last date. That's why. Because you are this undertaking you are giving to the court that you will argue the case on the next date of hearing. So that's why we are recording your name. So then if you don't argue, the appeal not only will be dismissed, we will issue a notice of contempt to you. Sure, no? Right. Good. For the applicant. Please for adjournment. This is a big accomplishment, right, for the day seeking an adjournment. A big achievement that 2014 appeal, 8 years, I sought an adjournment. You should be happy, right? No, the problem is that today we are free, you don't want to argue. Some other day, we don't know what would be the position tomorrow. We do not know. So, waiting, expecting that it should be listed for a day when it is not called. submits that the arguing counsel, Mr. C.V. Nagesh, is not available on account of personal difficulty. Reluctantly hearing of the appeal, full stop, learned counsel for the appellant, Mr. So and so further submits that undertakes to argue the appeal in case senior counsel is not available on the next date of hearing. In view of the aforesaid undertaking furnished by Mr. So and so, hearing is deferred. List on 19 January. Yesterday, we were waiting and it's not called. And what to do? It was argued for some time. Then for the appellant, even when matter is called in second round, so and so learned counsel correspondent awaiting appearance. Hearing is deferred. Just after 1 week.
Sir, 56. A. Rahul Kaliyappa, A. Karambaya.
Huh? You are well, right? You are all right. First day, that the best day to argue. First day is the best day. All right, what is it? Huh? Huh?
Medical report, sir.
We don't need medical report, madam. No, nothing. We are asking you what is this appeal about? Who has filed the appeal? Speak into the mic, madam. Be comfortable. Yes. What is this appeal? Who has filed? Huh? No, you should tell us who has filed this appeal. What has happened? We don't want that you should begin your career by adjournment. Yes. You have the file. You don't have the file. Please, we'll give you. Yes, you have the file. You have the file. Then yes, tell us who has filed this appeal. Which provision it is filed. Who has filed? What is 13 clause A 1A? Not aware? You cannot claim right to ignorance, right? Like right to education is a fundamental right. Like that, you cannot claim that I do not know. You have passed the LLB examination, madam. You have passed, right? LLB examination. When? Which year? 2020. So this was Hindu Marriage Act must have been one of the subjects which is taught to you, personal laws, right? Subject, you must have read it as a college student. So how can you say I don't know? That means, I mean, should we this thing? Presume that you have been wrongly passed and you should have failed the examination. Then what? So now the book is in your. See, find it out. What is the ground? Yes. Huh? What ground? So which the petition has been filed seeking divorce on what ground? Which ground? One 1A. What is 1A? Read. Read this section aloud. We also want to know what is it. So file the petition. Who is seeking Konappa? Yes, go ahead. Madam. So husband filed a petition, right? Husband filed a petition seeking dissolution of marriage on the ground of cruelty. What grounds? What is cruelty? What was pleaded? Read it, madam. If you don't have the file, we will give you. You have the file, right? Read this paragraph. You will of the judgment. You have the judgment. What is the judgment? Paragraph 3. Read paragraph 3 of the judgment. In brief, Honorable, read properly. Of course, we did not. Unfortunately, your colleague is standing, I mean, she's there. She knows that this court is not inclined to grant an adjournment. So she is standing there and she has sent you here today on your first day. And since you don't know the code, therefore you have come. You are giving us. Yes, go ahead. Read. What's your name? What's your name? No, we are not the, you don't address the judge as sir, right? We are not, you should. No, this is your first day. So first find out how to address the court, right? And we don't grant leave to anybody. So therefore, medical certificate, you cannot pass on like this through a court officer. If you want to file any document before the court, it has to be accompanied by an application. And that's not the place where you file documents. Then if you haven't known, there is a place called something filing section where all documents are filed. We don't entertain this thing like documents like, and we are not granting leave to your senior. We are not the sanctioning authority. We are not deciding that he is unauthorizedly absent. Not his employer, right? Are we your senior's employer? Then why are you showing us medical certificate? First, find out how to address the court. Huh? You find out how to address the court first, before walking in any court and write her name. What learned Miss Kaveri, learned counsel for the appellant, submits that arguing counsel, Mr. Rahul Kariyappa, is unwell. List in the next week. Don't come to this court, otherwise we will make you argue, madam. Don't come. First day, that's why. Otherwise, next time we will be tough. Don't come here to seek adjournment. Yeah. 57. No, it's all right. You should know. Yes. So yes. He is appearing correspondent. Marriage. What was your age? 11. So not void. It will not be void. And when it will be void of that, void of right at the instance of the void. Not at the instance. And that will What does it say?
Viability of marriage is divided in section 11. And it raises kind of why this quantity five plus four and five to marriage. I want you to come in five of three, which is not avoid marriage in terms of.
So, which provision of section 12 avoidable? So,
1, 4 and 5 is void.
it's 3. No, you only said that it is voidable at the instance of husband, so we are asking wife. So where is that?
Subsequent. Otherwise, not. It cannot be avoided. Void marriage is defined. Viability cannot come to various other things where this is not down there. Gila Gupta's case, 5, 6, 7 and 10.
What is the effect then? Where do we get it voidable at the instance of the wife? In this judgment, has it been held? What is the prayer made by you in the petition? By the respondent, rather? Yes, Mr. Huh? Why? Okay.
very.
That's not the ground. Not void and resolution on the ground cannot be granted.
Please for the void.
Huh.
Let's find it.
We'll set aside the mandate. It can't be declared as void. Hello?
Really. Yeah. Keep it for further hearing.
Huh? All right, further hearing tomorrow. Learn okay. Learned counsel for the applicant submits that the family court ought to have appreciated that that section 11 of the Hindu Marriage Act 1955 was not attracted to the fact situation of the case as the marriage in question was not performed in violation of section 5 within bracket Roman 1 within comma Roman 5.
Void marriage in. Marriage would not be void marriage in your section.
Huh? 1, 4 and 5. What is it? What? Learned counsel for the appellate.
Family courts could have appreciated that section 11 of Hindu Marriage Act was not
Applicable to the fact situation as the marriage was not held in violation of section 5 clause 1, 4 and 5 of the act. Let the appeal be listed for further hearing tomorrow.
For 58. Babu.
Nobody.
None had appeared on behalf of the appellant even on what date? Yesterday. 10th of January 23, none has appeared on behalf of the appellant even when the matter is called in second round. Data line below appears not interested. Dismissed for want of prosecution. This was argued? No. This is the MFA.
Against the order of restoration, this is fine.
Ex parte judgment is restored.
Order 9 rules. That is not.
Dismiss. Dismiss.
Even otherwise, it will not survive because the petition has not already disposed of.
All right. Yes.
But that only second.
Yes.
The petition after restoration has been disposed of.
Disposed. Oh, nine. Yes, this appeal. Just a minute. This
There are
appeal.
two appeals.
This appeal under section 19 within bracket 1 of the Family Court Act has been filed against matter dated 13th of February 2015, by which the by which the petition filed by the respondent under Order 9/2015 of the Code of Civil Procedure for setting aside the ex parte judgment and decree passed judgment and decree dated 5/4/10. The counsel for respondent submits that in compliance of the that after the aforesaid judgment, aforesaid order was passed, the petition filed under section 13 of the Hindu Marriage Act itself has been dismissed for want of prosecution on 4/9/2015 paragraph. In view of aforesaid subsequent development, nothing survives for adjudication in this appeal. Accordingly, same is dismissed as in. What is the other question? Petition filed by partly allowed appointing him natural guardian of daughter Tanushri. What happened? What happens to the son and daughter?
What is the age? It cannot be.
Daughter is 2005 born, right? So 15 to yes.
17.
And son is 20. Prosecution.
Appellant.
You are the appellant. Why should? So
Who has remarried? Find out.
you file an just orally saying. Well, which para? Page 5.
List it and tomorrow. Study of it.
So and so learned counsel to the appellant, none correspondent. Learned counsel for the appellant submits that during the pendency of this appeal, the respondent has remarried and children are born to him from the second marriage. Let the appeal be listed. No, in the awaiting appearance of learned counsel for respondent, hearing is deferred. List next week.
Number 60. प्रकार के हैं He was made to believe that the matter will be settled immediately. So that the son and the wife can have it provided with details. On that assurance, she was learned efficiency. She filed an application regarding where the cross examination will be taken as a nil. So last week I will see this page number 63. 63 of it is an application filed by the parent. Reading the trade application, the applicant itself, the learned, they can be put stating that case is posted for availability. But then respondent that the marriage there is some part to them. And also no maintain the same not disputed. Subsequently, the events taken by the other side of the had already married. So, understanding post it question, and the marriage was taken, then after the slave of the marriage, or before the slave, by the was it was the marriage. Subsequent, if he changed the motive and subsequently, in another state, saying that no, he has not. He's living. Taking advantage of practical.
What are you arguing? This is final hearing, right? So what are you arguing? You haven't told us what the facts, nothing you are saying.
Yes, there is knowledge is big. But writing, you will fix up. The law of something inside of that, we need that. I don't know, I at least get some provision for the. Hey, sir, you need something from previous one. I mean, that's a good. And,
We don't decide the case by what he says, right? We decide the case on the basis of material available. What he says, it's his choice. He will say, I am the king. So what can we do? How much?
You're now remarried. The alimony amount your party is ready to pay. What is the alimony amount your party is ready to pay? No. What is the instructions with regard to the amount which your party is ready to pay? Is she earning? You're employed.
Maybe working because they had no other issue.
Sir, the question is very simple. Are you employed? File.
Says. He can't expect simply because they are there.
You file your affidavit with regard to assets and liabilities.
He asked this, somebody they put this on. Presently, totally he made a submission that I'm already married, I have already had a relationship. See, because no, I don't want to do anything. Let whatever the court decide, let it decides. She doesn't draw wrongs. So she can do. That is all. He said that I have died involved with him. He has not made any provision for us. Let the court decide. These are the facts not disputed by others.
We want to know what is the income your party is earning. She is earning. Mister, you are a counsel. You know what the law is. You are required to file an affidavit with regard to assets and liabilities. If you don't file, we'll draw an adverse inference against you. Yes. If you are if that is so, we'll record your statement. You are not going to file it, and we will draw an adverse inference against you. Yes, we will record it that she is not willing.
What is the legal position? You are an officer of the court. What is the legal position? Client may say anything, he may say anything. Does it decide the fate of a case? So what are you arguing? What Supreme Court has said with regard to assets and liabilities? What is the law? Huh?
Not sure. You are not she not offer break of she said that I will again I have made you are comfortable to you are legality. This matter was allowed before the court being. Instead of change substantially.
Perfect argument. Substantial justice. Substantial justice. Technicality allowed. Mister, you don't understand, right? What is the law laid down by Supreme Court? Parties are required to, you are saying that we should fix an amount of permanent alimony. Parties are required to file statement of assets and liabilities that has been held by, which is that decision? Mr. Give it to him. He won't read it. Fine. So We are just telling you, if you don't want to file, we will have to draw an adverse inference against you. Mister, you tell him, Mister. Get rid of this. What are you doing? What are you doing? Huh? Oh. Living with the this thing relationship and doing nothing. So how does he survive?
What is your property? How much property you have got? A residential building with ground plus 2 floors. Another site. How many children from the wedlock? 1 or 2? Only 1. Boy or girl?
Son is there.
What is the age? So then 9, 14 years.
He's a serious health issue. Amazing. Made her go through and
And from the from the second relation, you have got 2 children from the second marriage.
Right? All right, we'll pass him over.
Tavares Gandhi, B. Narayan Swami.
Yesterday also nobody appeared. And was it listed yesterday?
I don't think. Huh? Listed.
None appeared on behalf of the appellant. On 10th of January 23. Today also, when the matter is called in second round, none has appeared on behalf of the appellant. It appears the appellant is not interested in prosecuting the appeal. According line below, accordingly, same is dismissed for auto prosecution. Yes. So You are seeking maintenance from your wife. Right? You are seeking maintenance from your wife. She is earning. You are not doing anything. So therefore, huh?
This is the ego problem. She is not perfect. You are, I mean, you are trying to better miscarriage is dying. You are in, anyone in Bella. You are in, anyone,
No possibility. How do we find out? Nobody's appeal.
Notice,
Mark his presence, none for respondent even though that is called in second round. Awaiting appearance. Hearing is deferred list. Write the whole sentence. Yes, sir.
Nobody is there for the other side. How to refer it?
Next week.
Next week, we listing it next week. Ask your friend to be present on the next date.
Huh?
50 is inclusive of education expenses and marriage expenses. So they had made a proposal yesterday, 20 lakhs and no, your offer is inclusive of educational and marriage expense, is it? Then
No, it's shooting. He wants 50 lakhs
50
plus.
lakhs and education expense and also marriage expense. You are working. Wherever it is, you are working, no? You are working. You have got an income. $33,000 is a decent salary. No.
Yes.
That's a very good offer. That's a very good offer. No, More.
Every day it
every-
will increase at the rate of 5
Everybody,
lakhs.
everybody wants more. That we understand.
Yes, madam, why to keep any scope for future litigation? What happens, like, we were just wondering that if we keep the expenses of education and this thing, marriage expenses, if we don't specify, in future, there will be always a scope for further litigation, right? Why don't you estimate this thing, include overall, make an overall offer of everything, inclusive of everything?
For that, you can take some time also for that additional thing.
Ah, yes. Oh, it will not increase like every day 5 lakhs, Mr. So you have to tell, I mean, that ask your client to be realistic, right? It's always better to have peace of mind rather than, so we will take it up tomorrow. Please find out. Yes. We'll continue with this. Government advocate.
For the respondent, my lord, in syllabus 65, please.
Fractured his leg.
Oh. Injured. But that you could have told us in the first round itself. So, Mr. You know, right? Arguing counsel. Is you don't know you. Now. So. When do you want? By that time, you will be all right. 30th January. Counting the dates, but advise him not to address us directly, or you retire, then he will appear, something like that. What to do? 30th January.
Increase on every day. Please come.
Yes, madam, please argue, make some 30th. See, I mean, the client is counting 30 or 20 times adjournment. Oh. All right. You have heard, right, what has happened. Learn it. So and so, additional government advocate prays for adjournment on the ground that arguing counsel Mr. Dhyan Chinappa is unwell. See, therefore, prays for adjournment on 30th January 20. So many cases listed, Mr. You didn't come. And when the cases are not reached, you tell us that it is not reached. I expected. No, this is the password round. First round also. No, Mr. You can't remain present everywhere, but your colleagues are anybody. You don't have any junior. Then what? Nobody appeared. They are also gone. Enjoy. Other courts seeking adjournment. Yes. So what happened? Yes. What? All right. Let's come to the case. She has argued. You are responsible for the career growth of your wife. You had contacts in the government, and that's why she was selected. Ah.
And after the engagement, also, we responded to this court.
So what's the point, Mister? You can't live, I mean, both of you, practically speaking, cannot stay together. Now. Acha. Ah.
Problem, there is a problem about.
That problem we will solve by our judgment, don't worry. So, we just asked. All right.
Marital home. They go through all of these. They go through. It's only a simple allegation. How many you have to buy one?
So therefore, no ground for divorce is made out, right? This is the argument.
What money is this? Some change like that. So you can- Canada. In yeah, women's college. We trying it up there. Not that I am living on her income. I am able to little source of income where I can live on my boss. You can also look up her, keeping apart her income.
No, but if she lives in village, how she will serve? She will have to resign from her job, right, to live with you. Ah. So she should, you are suggesting she should commute every day from village to college? No. Ah. Ah, yeah, 10 minutes.
From village to big city. Either this is inside Mother or India. And if I accept to go to my in India, India I can be working in some people or some Nigeria or somewhere else. If far away, there she can't stay back. You can understand. We can't have case also. He is working in Mandya Women's College, and which is about 10 kilometers away from my native place. Only they need to get away from the management.
Most of the husbands would have felt happy, dislike, but you are an exception. Lighter vein, Mr. Prakash. Yes.
In this case, only allegation is that I made an allegation regarding illegal connection with somebody. That is the only case that will take.
Principal.
Should not be That could be rectified to be a practically like something defined. Suppose if you go out, read how the society looks at you, no. Instead that live a happy life in the family. My village is situated about 10 kilometers.
Hey, we don't know. We just ask, you are saying about village and all. We don't know. We will decide it on the basis of evidence or record. You are arguing that way, that's why we ask. We don't know whether it's 10 kilometers or what.
He wants to go because he's part of the continent. He wants to go out of the America. Then it will be allowed the absence of any allegation of fluidity or something. If they are not made of any allegation, it will also look at the other. Yes, so much in reported in the SC, it was very regulated incident of long past and the group found to have been controlled due to compromising behavior of the party. After an act of cruelty, it is the meaning of the 13 months, 1 year into that. Because both the some verbal conversation, it would not be sufficient to cruelty. It is further supported by incident like all the allegations to the petitioner's wife and denial of the responding husband like wife. Allegations of the responding husband and denial of the petitioner's wife indicate that their dispute can be resolved only with their sincere effort. There are small and unfortunate issues between them after their marriage. It needs to be addressed by mutual understanding. The main grievance is that it was hurt by behavior of the husband responding. But this was find no incident where the responding husband used to behave with the petitioner or his behavior or cruel to the petitioner, where the parties were deciding separately since long. They charge their spouse on false ground. This court goes that the petitioner and respondent would realize their duties and obligations in each other, as also realize their joint obligations as father and mother to one faith. Both to for each quite burial their past deeds, acts, and bitter experiences, not living together. And see that their faith and their family are well situated respectively. Such creating is for peace to be interest of all families with all love and bring peace in harmony and happiness. When past values is petition evidence, I am of the view that the petitioner wife is not entitled for clear divorce. The rest is respondent is clear to me that it was the petitioner wife who withdraw from the company. It is clear to me that it was the petitioner wife who withdraw from the company of the respondent without reasonable cause and not the wife's was off. In such a circumstances, possible solution is certainly possible. The parties reconcile themselves and leave to the community their path. The objection to the respondent also claims to grant a degree of excuse on the right way of life. Such counterclaims will have the same effect as a lawsuit, so as to enable you to pronounce written judgment. The petitioner shall be at liberty to the officials to answer the counterclaim of the respondent. The counterclaim shall be treated as a claim form. property from father. About to take the meaning further examination whether when we have the examination. Taking examination. So the day for the hearing need. I think God is very. For the betterment of the now, forgetting the differences that are about we have. We out of the so we have solution or whatever. The reason why we do not take a format. Past. Thinking the interest of the pay. When they are therefore, the order department is well increase the account income. The district of the Brother, why is the okay, let's go right ahead. Yes, I get it. But statement made by him, the effect that the child is born with it, will it not affect any woman to them? I think it's very clear from my statement. He had stated. This child is born with very this system shows that the baby was arrived. When the panchayat asked him why you are behaving like this, the answer given by him is the respondent has given evasive answer by saying that she is my wife, I can do whatever I. This is the adultery stage. He was treating his own wife. This is the examination of PW2. There were three panchayats. And all these three panchayats. He used to go back to three panchayats. One in 2000, one in 2011, one in 2000. And there were so many allegations. He used to use the card.
Make her feel that it's not worth to do. And he himself has made a money in the Everybody is down on me. And it is very difficult. There's a Supreme Court.
It must be a reported case, madam. What is the civil appeal? It's like it's available like free.
They are here.
Hmm.
2021,
Why can't they
107.
Right?
If it is online, they take it themselves.
Which paragraph?
Yeah, in having and we
Where is it that he has made a in campus?
Yeah. He goes and makes calculation of this, and he is calling When he was asked like why he is doing all this. And the panchayat, the two panchayat, something.
What is he doing? For a small landowner. Income. 1 acre of land, what income is? About 4 acres of land, is able to supply 5 acres of land, is able to supply 80 tons sugar cane. Of which for getting charge itself 800. And for getting charge itself from land to road is 300. And the year completely I have to cover the both of the all is calculated. I suffered loss. But we have to grow something because to create revenue, otherwise it will be a fallow land. So what you write, we have to grow something. We know a farmer knows reality, we are unable to take anything. That you only we are setting a lab. It will be hand to mouth and for something. Government. No, APSD where the temporary environment because you will not when the time of in the chief minister saying, chief minister for to continue, you have continue. There are once he was in this BA and he was working as a secretary, private secretary of something or PA to some thing. That time got by at least they thought of we cannot be continue legally. We see later get the job and now she was made to qualify and to get a job. This house in that scenario she got because I am a BA graduate, I am either here or there. This is the background. There is no speaking schooling something not very speed. So we never went there. There is something not very big police report. Calling me why you are making nuisance going to the college. Finding mercy left matrimonial home. I used to go after leaving the matrimonial home to her college making nuisance. Immediately go.
That's it. All. Yes. Awesome order.